I'm often asked, Aaron, how are personal injury lawyers paid? Well, the answer to that is pretty simple. Personal injury lawyers are paid on a contingency fee, which basically means a percentage of the recovery. This is something that you need to discuss with your lawyer, but it essentially means the attorney, if successful, is going to be entitled to a percentage of the recovery as compensation or attorney fees. So the attorney will not be paid unless there's a successful financial recovery. Further, if the case is unsuccessful or the claim is unsuccessful, you don't owe the attorney anything. You don't owe the attorney anything for fees, attorney fees. You don't owe the attorney anything for the expenses and the case-related expenses. Now, each case is different, so the specifics of your case and the actual percentages, it's something that you'll need to go over with your injury lawyer. Now, some cases and some claims, the law will specify the percentages. For example, in Alabama, the workers' compensation fee is set at 15%, which means in Alabama workers' compensation cases, if the attorney is successful in recovering for you in your workers' compensation case, they're entitled to a 15% attorney fee. Now, the standard in a clear liability automobile wreck case that settles without litigation, as a general rule in Alabama, is a 1/3 contingency fee. But again, each case is different. The facts and circumstances often have to be taken into consideration. For example, it may not be a clear liability. Liability may be in dispute. Alabama recognizes contributory negligence and other defenses that can make an automobile wreck case more risky. So it may not always be a 1/3, but as a general rule, as a rule of thumb, a clear liability automobile wreck case that settles without litigation in general is a 1/3 contingency fee, which again means if the attorney is successful in recovering for you, they're entitled to a 1/3 attorney fee. Now, the case expenses have to be considered. So you'll want to know, are the case expenses taken out of the gross settlement? But in general, the way it works with us, the case-related expenses, in other words, expenses for ordering medical records, expert fees, will first address cases that settle outside of litigation, okay? So generally, in those cases, you're going to have some medical record expenses. Potentially, there could potentially be other expenses if there's an accident reconstruction investigation or some specific type of expert required. Again, these are things that you're going to need to talk with your attorney about. But so often, in so many of the car wreck cases, it's going to be medical record expenses. So those expenses would come off the top or out of the gross settlement. Then the attorney fee percentage is going to come out of the net. People often want to know, well, what about outstanding medical bills and medical liens? That is going to have to be paid out of the client's portion or out of your portion of the settlement. But again, these are all questions and things that you need to go over with your attorney to have a clear understanding. Now, automobile wreck cases that go into litigation, or automobile wreck cases that are outside of litigation but more risky, the percentages could be 40 and sometimes 50% once the case goes into litigation. Again, the insurance companies in Alabama are able to take advantage of something called the collateral source rule, contributory negligence, assumption of the risk. There are so many defenses and advantages oftentimes that insurance companies have that you need, and defendants have, that you need to talk with your attorney about, because that can impact the percentages. As a rule of thumb, once an automobile wreck case gets into litigation, the fee is going to be somewhere in the range of 40%. However, there could be risk factors and facts and circumstances that might take it below 40% or above 40%. Then once a case gets into litigation, there are expenses, witness expenses. In Alabama, in order to prove your injuries and damages in an automobile wreck case, you've got to depose the surgeons and the medical providers. That costs money. You also have to hire court reporters and videographers. In some cases, there may be black box experts, accident reconstruction experts, again, when liability or fault is contested. So all of those expenses would have to be paid out of the recovery. So again, this is something that you need to talk with your attorney about. There's also a category of injury case called premise liability cases. And in premise liability cases, in other words, where you're hurt on someone else's property. So again, in Alabama, there are facts and circumstances. There's legal defenses that property owners and defendants and insurance companies can utilize. So as a general rule, the percentage in property cases is, as a rule of thumb, in Alabama in the range of 40%. Depending on the facts and circumstances, it may be lower, it may be higher, because there's risk factors and the things that you have to prove. You have to prove that the property owner was either negligent or reckless, and you've got to overcome any defenses that are available. So again, if the case goes into litigation, there's going to be the cost and expense of witness depositions, medical depositions. Sometimes an expert is required. So these are all factors that you need to discuss with your attorney. However, again, I'll reiterate, if the litigation or the pursuit of the case is unsuccessful, even if experts are hired, even if depositions, the expenses run up with deposition costs, even in those situations, if the case is not successful, in other words, there's no recovery, there's no settlement, there's no judgment, then you don't owe the attorney anything for attorney fees or expenses. Alabama has another category of case called product liability. We often see this in automobile wreck cases. We often see this in work-related injury cases where someone is injured by a defective machine, the defective machinery, equipment, a defect in an automobile. So those cases generally require advance in costs and expenses related to experts, related to investigators, the litigation costs, expert witnesses, depositions, court reporter, videography. In order to prove the case, in order to make it through litigation successfully, it's not uncommon for those cases to incur $50,000 and over $100,000 in litigation costs and expenses. Those are all advanced by your attorney, and in those cases, as a general rule, because they're going into litigation, because the expenses, because of the risk, the defenses, everything that goes into it that you need to discuss with your attorney, as a general rule, those cases are handled on a 45% contingency. Sometimes it may be, depending on the facts and circumstances, less. Sometimes it may be up to 50%. But again, these are things that you need to discuss with your attorney. But as I said earlier, even if the expenses, even if the case goes through trial and money is spent and the case is not successful for whatever reason, you don't owe your attorney anything for fees or expenses. We're glad to answer more questions about this, so feel free to reach out if you've got questions about this or concerns. We're here to help, and we're here to answer those questions.